Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad IZZUDDin bin JAMALLUDIN. My matriculation number is 244373. Today I would like to presenting my case review regarding my thoughts on the subject of law of evidence. I have thoughts to give a review on the case of Regina against KILBOURNE. This is an appeal case where there are five sitting judges led by Lord Hailsham, Lord Reid, Lord Morris, Lord Simons, and Lord Cross. In this appeal case, this is an appeal case made to the House of Lords, where the respondent was convicted of one offence of burglary. The respondent was convicted alleging offence against two different groups of boys on the offence of burglary, but the offence against the first group a year before the offence against the second group. This case was started on the trial of the trial judge, which is the judge has convicted of 5 years imprisonment for the accused, and then they dissatisfying with the conviction. The accused made an appeal to the Court of Appeals, where he raised an issue of whether uncorroborated evidence of bias in the first group capable of corroborating evidence of bias in the second group, and then the Court of Appeals allow the appeals. However, the dissatisfying for this decision made by the Court of Appeals, the appeal in this case, the Director of Public Procedure appealed this case to the House of Lords. The issue arises is whether uncorroborated evidence of bias in first group capable of corroborating evidence of bias in second group. As why this issue been arising, because in the trial the judge directed the jury that they would be entitled to the uncorroborated evidence of the second group of bias if they were satisfied that the boy was speaking the truth as to what the appellant had done to them, so as supporting evidence given by the first group of boys. And then there are several decisions on the different courts has been decided in this consequence of this case. The first is in the learned trial judge had decided to convict the accused with the 5 years imprisonment due to the convictions. And in the line of Court of Appeals, after the accused make an appeal on the sentence, the Court of Appeals allow the appeals and reverse the decision made by the trial judge. And then in the House of Lords, there is no decision to be determined yet on this case. In my point of view, to understand the law of corroboration is must to know the actual general principles of the corroborations. The meaning of corroboration is questionable whether a strict definition of corroboration is either necessary or desirable. It has been said by Lord Reid and the Lord Hailsham such in this case that there is nothing technical in the idea of corroborations. The term has been variously defined. Lord Hailsham in this case said that the word corroboration by itself means no more than evidence tending to confirm other evidence. Also, it's been supported by Lord Morris that suggests the idea of corroboration is evidence tending to confirm and support other evidence. It is evidence which renders other evidence more probable. In line with our law positions, where the corroboration has been stated in the section 134 of the Evidence Act 1950s, where provide that for the number of witnesses. In this section stated that no particular numbers of witnesses shall in any case be required for the proof of any fact. I will translate in Malay, where tiada apa-apa bilangan tertentu mengenai saksi dikehendaki dalam sesuatu kes untuk membuktikan sesuatu fakta. This particular section provides that no particular number of witnesses shall be required for the proof of any facts. This means that the testimony of a single witness, if believed as such, this case is sufficient to establish any fact The result of this session is that in any case, the testimony of a single witness, if believed, is sufficient to establish any fact. The court may act on the testimony of a single witness even though uncorroborated, or openly prove that the commentary evidence without such testimony at all. It can refer in the case of C. Wright vs. Statham and Cao Cheng-Bok vs. Cao Chen-Pok in this MLJ. So it can be concluded that section 1334 of the Evidence Act 1950 follow the maxim testes parenter non numerantes, whereas this means that evidence is to be weighed, not to be counted. So that after I have read go through to all this case, I also agree with the court or appeal in saying that evidence of each child went to contradict any possibility of innocent association. As such, it was admissible as the part of the prosecution case. And since by the time the judge came to sum up, innocent association was the foundation of defense to put forward by the accused questions. The word corroborations. Furthermore, the word of corroboration itself means no more than evidence tending to confirm other evidence. In my humble opinions, evidence which is admissible and relevant to the evidence requiring corroboration, and if believed, confirming it in the required particulars, is capable of being corroboration of the evidence, and when believed, is in fact such corroboration. So that's all from me. Thank you.